Good morning, everyone. I'm Tonya Nunez. I am the Director of Metro Montreal Lawyers and Pro Bono Programming at the Colorado and the Denver Bar Associations. Welcome and thank you for being here. We are going to get started pretty soon. I wanted to keep muted. We are going to have the availability to put questions in the chat, and I will monitor that as we go through with our speakers. Wanted to remind you that we are always looking for volunteers. So that's part of why we do this, is to recruit. And today you'll hear specifically about our family law court program in particular, and that really is something where no experience is necessary. So thank you for joining us. We'll be sending materials off, and I'm going to hand it all over to Liz.
All right, good morning, everyone. Thank you again for joining us today. I'm Liz Jones. I am the Family Law Court Program Coordinator for Metro Volunteer Lawyers. So today, as Tony had said, we're going to learn about simple family law cases and how to handle them, and we hope to encourage you to give it a try by signing up for our Family Law Court Program. Our speakers today we have retired Judge Edward Moss. He was a district court for Broomfield and Adams County for 16 years before he retired in 2020. Before being appointed to the bench, he was named a Denver Metro Volunteer Lawyer of the Year, and he is a longtime member of the Colorado Bar Association's Ethics Committee. Currently, he is of counsel with the Denver law firm of Chancho Brown. Sahar Safi practices exclusively with family law at the Denver law firm of Bono. She's deeply committed to helping individuals navigate their family law matters, and she was previously the Family Law Court Program Coordinator for Metro Volunteer Lawyers before shifting to private practice. So with that, I will turn it over to Sahar.
Good morning, everyone. Thank you for joining us. So as Tony Ann and Liz mentioned, we're going to be talking about handling relatively simple, quote unquote, simple family law cases. And it's going to kind of track with the Family Law Court Program, which I'll often refer to as FLCP, because that really is a good opportunity to kind of work through one of these cases with the support of the MVL staff and other volunteers. But it really does track a regular case through the courts as well. So obviously the initial step is really that kind of consultation. When a client approaches you, or a potential client, and wants you to represent them, you're going to want to get obviously as much information as you can. And for these types of cases, a majority of the time, the estates are likely going to be small. There will probably be children involved, but the other party may not be involved at all, or is in agreement with everything. And so kind of getting as much information as possible at that initial step is really going to be beneficial. Now, in the Family Law Court Program, Liz does all of that. She gets the information, she gets the county where we're going to be filing, the names, addresses, all those things, and kind of puts together a packet to set up that initial meeting, which is really when the case gets started. MBL gets those cases through intakes conducted by Colorado Legal Services, which kind of partners with MBL and the Family Law Court Program to get these clients the assistance that they need. But really that initial step to getting the case filed is going to be that meeting. And the FLCP initial consultation and meetings happen monthly in the Denver metro area. And that's where really you're going to fill out the initial paperwork that you would, even if you were handling this on your own. So you could do it through the FLCP program, but the process is essentially the same. Those initial pleadings are, pretty basic. I believe you all have a copy of the JDF forms. A lot of those are, relatively simple information, basic information, names, addresses, names of children, birthdays, length of residency in Colorado to ensure that they're standing, one of the parties needs to have been in Colorado for at least 3 months prior to filing. The children need to have been here for at least 6 months prior to filing or since birth to establish Colorado as their home state for Colorado to have jurisdiction. So those are kind of some of the things that you'd want to be looking out for in that initial meeting. If you were to volunteer with FLCP, all those JDF forms would be provided for you. You would be matched up with a client to get all of that going. So you would be there with an individual in a room kind of similar to this, or a conference room. The petition is really the first form to complete. Like I said, pretty basic information. Names, addresses, names of children, if there have been any other cases filed, things like that, child support, if there's a child support case open. And then the case information sheet, which is very similar to the petition. It has a lot of the same information. And then the summons, which is, you really just fill out the caption on that one, as you can kind of see on the JDF form. In those initial meetings, like I said, Liz kind of pairs you up with a client. If you were going to go through this FLCP program, I just want to make it clear, absolutely anyone can volunteer and come get this experience through the program. Attorneys, law students, paralegals, new attorneys, seasoned attorneys, attorneys wanting to just see how a family law case works, and no family law experience is needed. Those forms really kind of guide you themselves. And then Liz is always at the meetings, and there's other volunteers there who can also kind of help you through the forms if you need it. Again, at those client meetings, kind of filling out that initial paperwork, a couple things to keep in mind is, you're paired with a client for that first time, you're meeting them for the first time, they're likely going to be very nervous. You may or may not have experience with the courts, but I'm sure you have more than the client. The client, this is usually their first time dealing with the legal system. They're nervous about the situation. They might be nervous about the other party, the information that they're going to be needing to disclose, going to court. They don't understand how to navigate the system, and they really need you to kind of guide them, to provide them information. They might have a lot of questions that go beyond the scope of the petition, case information sheet, things like that. Like I said, Liz is going to be there to field those if needed. Other volunteers, if you're ever unsure of how to answer a question, there's always help there. When you are kind of paired up with a client, it's always really nice to just do, a few minutes of pleasantries, get some background, things because with these clients at FLCP, you haven't done that initial consultation. For the clinic, it's kind of like a consultation initial meeting at one, whereas you were taking a case private practice, you likely have done a consultation and now we're meeting to kind of complete all the paperwork. It's kind of split into two, whereas this is really just one, but the process is still the same, right? Exchanging a couple pleasantries, getting some background, putting them at ease as much as you possibly can. Being patient is always going to be helpful in any situation. Now, along with the initial paperwork, the petition case information sheet summons, that's all you need to get a case started. That is what you will file in the county that that the case is going to be filed in. You would file where the other party is residing. I'm sorry. Now, a lot of times in FLCP or in these cases that we're going to be talking about, maybe they don't know where the other party is residing, or they've been separated for so long and now they've just realized that they are married. We had a case once where an individual was seeking to get her Social Security benefits, but had never actually gotten divorced, and it was going to affect her benefits. And so she needed to go through the legal process of actually getting divorced because they separated years before and had never actually gotten divorced. So every situation is different, but a lot of times they might not know where the other party is. And in that situation, we usually file where the children are or where the petitioner is going to be the client. And so when you're filing a case, you just e-file it, you get a case number assigned to you, you get those court stamp copies back from the court, and we'll work on service. And I'll talk about that in a minute. When we're going through the FLCP process, you fill out actually a few additional forms that you would file in a normal case as well that you're handling in privately. And namely, that's really going to be the sworn financial statement and the certificate of compliance. Those are very important forms in any domestic relations case. And that's really what's going to take up the bulk of the time at a client meeting or in kind of the initial steps of any sort of DR case. As you can see in a sworn financial statement, you guys have the JDF form. It's about 8 or 9 pages, and it really goes into the client's assets, debts, income, expenses that they have, and that you want to be as accurate as you possibly can. And that really takes a long time because, for example, a lot of times clients or those individuals at the clinic haven't really thought about, how much money do they spend on gas, or how much does it cost to how much is their clothing expenses for their children. And they really have to think through what their utilities are, what they spend monthly, what all of their debts are. Do they have any assets? How much is their car valued at? If you were doing this outside of the clinic, you would want to get, some additional documentation. Colorado Rules of Civil Procedure Form 35.1 lists out all the documentation that you would be needing to get. Tax statements for the last 3 years, bank statements, pay information, things like that. It's a whole long list of documents. And I always tell my clients, it's kind of like doing your taxes. So you just need to gather everything and kind of sort through it to make sure that that sworn financial statement is as accurate as possible. In the clinic setting, you don't really have the time to do that. And these clients have been financially screened. So for the most part, they likely don't have significant assets that they're going to be needing to disclose. And they're not making a significant amount of money, or else they wouldn't qualify for the program. So the 16.2 disclosures that I mentioned, those are pretty vital in a case. They're very important. The sworn financial statement is also very important in the clinic as well. It's just that the clientele is a little bit different because they don't have things that they need to disclose. And so in the clinic setting, we're not really working at gathering all of those documents, presenting all of those documents. The courts understand that this is a specific program that is designed to help these clients just get through the system. And so they understand these clients' backgrounds, and we haven't really had, issues with that as long as the sworn financial statement is very complete and we're completing that certificate of compliance. So that's something that you're going to be needing to complete in the initial steps of any sort of DR case. Like I said, it's going to take up probably the bulk of that first, once we file kind of that first initial progression of the case, just because it is pretty detailed and it's a bit time consuming to gather all of those things. But, it's pretty, the forms are very straightforward. The other thing to really keep in mind towards the beginning, once the case is filed, is getting the other party served. Now in the clinic, we'll talk about how they kind of do that. But for the most part, you're going to want to look at where the other party is residing and where they work, and then either get a process server or a sheriff, or it might be possible that they're going to be signing a waiver of service, but they need to be served in order to have jurisdiction over them. Like I said, in a lot of these cases, the party who is seeking assistance doesn't know where the respondent is going to be, where the other party is. Either they've been separated for a long time, or it may be not even that long and they just don't know where they are. You run across that a lot in the clinic. And so you provide as much information as you possibly can. And the last resort is really to do a motion for publication. In the clinic, you would not be doing that. Liz actually handles that and gets that going in the court system. But that really is to show the court that you've tried everything to get the other party served, and you just don't know where he is. But that should not prevent this individual from getting their divorce. It limits some jurisdictional issues like maintenance and things like that. But in these cases, you're likely not dealing with that anyway.
So I have a question.
Sure.
What if after the sworn financial statement is filed, circumstances change?
So, and these cases do take time. So a lot can happen between when you file your sworn financial statement for your client and either permanent orders or even before mediation. So you would want to update that or amend the sworn financial statement. Either maybe somebody gets a new job, loses their job, gets new assets, or maybe something that you were unaware of, that you didn't know about, you find out later. So you would just file an updated sworn financial statement and make sure that it's aware. You do have a duty to disclose and make sure that everything is as accurate as possible. So just file an amended or an updated one. In these cases, a lot of times you're going to want to update that anyway. Like I said, a lot of time goes, it can be months before mediation or permanent orders, if you're even going to mediate. And so you'd want to update the others, you'd want to update the courts regardless. A couple things to keep in mind with the clinic clients in their sworn financial statement is, like I said, you're going to really want to help them think through their monthly expenses information and things like that. But also, you know, some things like, do they get means tested benefits? You know, does that count as income? Does that not count as income? Is it something, you know, so you just want to disclose as much as you possibly, because it is a sworn document, make it as accurate as possible. You really want the client to stay focused, especially when somebody's talking about their finances. They might feel the need to explain away certain things or why they have so much debt. And, you know, we're not judging anybody. We just need the information, you know, so just kind of helping people stay focused and getting everything on the form. They'll want to explain circumstances, which is good background to have, but really you just want to keep the form as accurate as possible. They'll likely have a lot of questions about what to include, and, you know, when in doubt, disclose. And then, and the great thing again about FLCP is, you know, if it's your first time, your 10th time, you know, and somebody asks a question that you don't know the answer to or kind of how to handle, Liz is at every single clinic. There are other volunteers there, and so there's always support there. Now, in the clinic setting, Liz then files the case and handles service. Obviously, if you're doing this on your own, you would handle service. Like I said, a process server or the sheriff are great options to get somebody served if you know where the other party is. If not, obviously, that motion for publication is what the route you're going to be needing to take. But really getting a case filed is that petition, case information sheet, summons. You get a case number, get the other party served, and the sworn financial statement and initial disclosures. That really takes you through getting the case going and initiated and kind of through the courts initially. The other thing that occurs within 42 days of filing the case is the initial status conference. That's really going to be the first court appearance. It's not always in front of a judicial officer, and many times it's actually not. It is on occasion, but a lot of times you're going to be meeting with the family court facilitator. With COVID and everything, a lot of times those are via Zoom or by phone. I have actually gotten a few notices recently of in-person initial status conferences, and I never thought those would be in person again. So if that does happen, and you really, you know, sometimes family court facilitators are open to you just calling them and asking if you can do it on phone, because, you know, it can be, you know, you're going to court for 15-20 minutes, and it might be easier just handled over the phone. But that initial status conference is really what allows the court to know what the issues are in the case. Now, these are, as we've discussed, pretty simple cases, so you're not necessarily going to be dealing with needing to explain that you have to get a whole bunch of experts appointed, parental responsibilities evaluation, or appraisals, or business valuations. You know, that would be something that could be a part of other cases. But in these types of cases, you're really just gonna, you know, appear, explain the situation. There may or may not be children. You may or may not know where the other party is. They may have been served by then to appear or not. But really it's just for the court to get that initial information so that they can kind of determine the next steps. And so in a regular kind of domestic relations case, they might order you to mediate. They might order another status conference, or they may set the hearing. In FLCP, they really just kind of set the permanent orders hearing, because a lot of times, like I said, the other party's not there. There's really no, you can't mediate with another side if they're not going to appear. So you kind of forego that. And you really just move towards permanent orders, which Judge Moss will talk about in a minute. But in another DR case, let's say it's uncontested, but the other party is participating somewhat or is involved, or you've been able to get them served, you would really then move on towards mediation, get mediation scheduled. You could do that through the Office of Dispute Resolution, unless you guys can agree on a private mediator. And that's really the best option, to just kind of, you know, reach an agreement, fill out the forms that Judge Moss is going to be talking about, and just kind of getting a resolution to the case. Now we're talking again about these relatively simple uncontested cases that proceed kind of along this trajectory of filing status conference and final agreements or orders. But that is, you know, a very, very brief summary of kind of the initial steps to getting these cases going. Any questions about these parts?
That's it.
While we're moving cameras around, get everybody situated. All right, well, also good morning. Let me wait till I get the high sign from the tech people here. All right, well, good morning again. My name's Ed Moss. We'll get a PowerPoint slide up here in a second. I retired in 2020 when I reached maximum age for judges. Judges are much like airline pilots. You reach a certain age and apparently you become dangerous. So we have something in our Constitution for mandatory retirement. For many, many years, I practiced commercial litigation before becoming a judge. So why am I talking about domestic relations? By fluke, when I was a very young associate, one of the senior partners came to me and said, I've got an old friend whose sister is getting a divorce and we're assigning that to you. And I said, I don't know anything about divorce. I just spent 2 years clerking for a federal judge and do divorces in federal court. And the senior partner said, well, nobody else here knows anything about divorce either, and you're the new guy. So after that, that case, strangely enough, went to Colorado Supreme Court. So that was pretty exciting. But after that, I kept some proportion of domestic relations cases. And there were two principal reasons for that. One, as a civil litigator, commercial litigator, I did a lot of discovery. I did a lot of depositions. I did a lot of motions to dismiss and summary judgment, but I didn't get into court much because most of those cases settled and had been scheduled for lengthy trials. But when you're doing a domestic relations case, it can be, a judge might only give you half a day. A judge might just give you a day, might give you a couple days, and you can get into court a lot. So that was the number one reason. You can practice up on your courtroom skills. Another reason was you got to meet a lot of judges and you got to meet a lot of magistrates. And I found that to be just important from a professional development standpoint. When I did have a commercial case or something in my specialty where I got back into the courtroom for something else, it was comforting, if you will, to be able to work with a judge that you'd already seen. One of my former partners is a longtime attorney in Golden, and he'd always wanted to have an office in downtown Golden, and you know they have that neon sign over the main street there. It says welcome to the West or welcome to Golden. He told me this story about a bar in Golden in the heyday of the cowboys and ranchers out there. One day, a three-legged dog walked into the bar, and the three-legged dog walked around and said, "Where's the man that shot my pa?" The good thing about doing this remotely is that you can't hear anybody laugh at my jokes, and that makes it pretty much the same as when I do it in a room full of people. So, all right, let's go to the next slide. This is your goal with Metro Volunteer Lawyers, to get a divorce in a day, at least for the work that I do with MVL. Sahar told you about all the work that goes into putting the file together before somebody who wants to handle the courtroom side gets the file. And when you get the courtroom side, you sign up for a date, you sign up either for a morning or for an afternoon. And if we go to the next slide, please. And the good news is you get there maybe 8 or 8:30 in the morning if you got the morning sessions. You are out by noon. And I used to tell my clients that I was representing in these family court law days that I'm sort of like Cinderella's carriage. At noon, I turn into a pumpkin. And one of the reasons I tell them that is if things are slowing down and you're afraid you're not going to be able to complete this, maybe that will encourage them to realize that if they don't get it done today, and most people are motivated to get it done that day, that they're going to have to come back another day. Maybe they're going to have to come back without an MVL, Metro Volunteer Lawyer, helping them. I don't know that because I just say sayonara to folks. There are times when in a morning session, I can only get through one case. There are times when I can get through 2 cases. And if you're a superhero, there have been times, not very many, when I've been able to get through 3 cases in the morning. And by 3 cases, I mean, do all the work with the client, do whatever negotiations you need with the other side of the case, and get in front of a magistrate or a judicial officer and get permanent orders entered. And I think that you will probably never have an experience like that anywhere else, getting through 3 cases in a day. All right, let's go to the next slide if we can. Among the best aspects of volunteering for a case for Metro Volunteer Lawyers is the fact that if you have never done a domestic relations case, or even if you have done domestic relations cases, you're going to get so many materials and so much help. It is going to make this really an easy experience for you. You're going to get pro bono pats on the back and credit for your pro bono work, and you're going to feel good because you've helped out a lot of people. One of the booklets that you're going to get is something called the Orientation Information for Volunteers. And if you, like I say, if you've never done a domestic relations case before, or even if you have, this booklet, it's 14 pages. It is beautifully organized. I must tell you, I never saw one of these when I was volunteering for MVL when I was a lawyer, and then 18 years ago, I became a judge, and I couldn't represent clients anymore. So when I came back, when I retired, one of the first things I wanted to do was get back and volunteer again. The materials that are available to you now are just stunningly good, including this orientation information. It is a 14-page checklist of issues and steps to take in order. So you're going to get a step-by-step outline. You're going to get scripts to follow for your courtroom presentation to the judicial officer. And if it's a marriage and a dissolution of marriage, you'll get a script for a dissolution of marriage. And if the parties have never been married, but they have children and they need an allocation of parental responsibilities, just court parenting time orders and child support orders, you're going to get a separate script for that. So there's a lot of reasons, even if you are experienced in DR, to go ahead and volunteer for a case and get all this assistance. All right, let's talk about next slide. And this one, as you can see, is entitled You, Judges, Magistrates, and Metro Volunteer Lawyer. So you will get the opportunity to appear in front of a lot of judicial officers because, frankly, I think the MVL days that you volunteer for these permanent order hearings are probably every couple months, maybe once every 3 months, whatever fits your schedule. I think they do it monthly. Is that right, Liz? Yeah, Liz says yes. Monthly in a variety of metro area counties. And I don't know that I've ever been in front of the same magistrate twice. They pass it around and you get to meet magistrates. It happens to be when I was a judge, from time to time, if there are no magistrates available, I would volunteer. I'd pop in and do some of these non-contested hearings and help out that way. So you'll get to be in front of a lot of people. The people you're appearing in front of know that you're a volunteer, and they know that they've got cases. They're kind of stuck. They're pro se people, not sophisticated. As Sahar said, I doubt whether any of them have ever been in front of a courtroom where they had to examine the other side, or whether they had to be aware of the magic words that we use, irretrievable breakdown, the other magic words. They're kind of stuck, and the paperwork is not easy. Any of you that have done divorce before, there's a lot of paper involved. The language is not everyday language, and we have unsophisticated clients, and it's really hard for them to get through the system. So the judges and magistrates know that you're helping these people get through the system. They know that on a good day, they can get 10 or 12 cases disposed of that would clog up their system, that would make their division clerks or the court facilitators that assist in domestic relations cases constantly on the phone, calling people up. Where are you now? What's going on? Why is there no progress? The judicial officers know that you are helping them and you're reducing their caseload, and they want to help you. So they'll be nice to you. Even the mean ones will be nice to you. And they'll be able to sense if you're new to domestic relations cases, and they'll grab the reins and they'll walk you through it. It's a great way. If you haven't done these cases before, it's a great way to break into the system and get comfortable in the courtroom. And if, like me, you volunteered for more than a decade with MVL, now I've started over. Even if you're experienced, to me, I think it's our obligation to provide pro bono services. Even if you're not a domestic relations lawyer, you can take these cases and go through with all the materials you get and all the people that are there to help you. And you can make your way through and do a good job for these folks, for the folks that your client, and even really for the other party to the lawsuit. So next slide, please. All right, so Sahar talked about all the stuff, all the hard work that goes in before you, if you're doing what I do, take the permanent orders hearings. Let's talk about what you do when you get to the courthouse. So the first thing that you do, let's see, okay. The first thing you do is you find out where you're supposed to be. So somebody hopefully will tell you what courtroom you're supposed to be in, or conference room, or meeting room. And you go to that location, and Liz, the program director, will be there waiting for you, or someone else from her staff. And you walk in, and as you get there, there's going to be a lot of litigants out in the hallway. They're going to be sitting on benches out in the hallway, or whatever the arrangement is. And you know what they're for, what they're there for. And they're watching everybody who looks like a lawyer walk in that conference room, because they want to know what's going on in there. So you go into the conference room, you will see a bunch of paper files on a desk in front of Liz. And you say to the MBL volunteer, don't say Liz if it's not her. You say, I'm new, please give me an easy one, because she will likely know, the volunteer, the MBL person there will likely know which of these files is the easy one. And if you're experienced, you go in and say, give me whatever you want, because I do this regularly, and I'll take whatever file you get. So you'll be handed a paper file, and you look in that file, and there's all those JDF forms that Sahar talked about, the Judicial Department forms that are already filled out, that were filled out in what Sahar referred to as the clinic side of it, the office side of it, the pre-permanent hearings discussions with the client. So the one thing will be in there is the petition, which I think is, you don't need to know this, but it's JDF, Judicial Department Form 1101. There'll be that case information sheet, all filled out. That has the case information sheet is really for the court clerks, and it gives them all the information on one page of what they want to enter into their electronic system: dates of birth, addresses, emails, phone numbers, children's names, things like that. One thing that is important is the summons. And because MVL has already taken care of getting the summons and the return of service, or if they didn't get service, a notice of publication. If there's service by publication, that should be in the file. Your client's sworn financial statement. That's the financial statement that Sahar talked about. It's got credit card debt and bank accounts and what cars they own and how much they think the cars they owe, and they own how much your client anyway spends on clothing for herself and for the kids and for whoever. And I want to talk to Kim for a minute. Kim asked a question about changes to the sworn financial affidavit. And it's a terrific question, and we will cover that in a little bit. And then certificate of compliance with mandatory financial disclosures. Those of you who are familiar with Rule 16.2 of the Rules of Civil Procedure, there's a section in there about what the mandatory disclosures are. You have to provide the other party access or copies of your bank account statements and any credit card statements and all their 401k statements and any statements that indicate the value of assets and W-2s and pay stubs and things like that. It's a big list that for an unsophisticated client looks enormous, but the people in the office before you get to the courthouse have already gone through that with us. So that should be filled out. All right. So those are filled out because the MPL folks in the office aspect of this have interviewed clients and they've arranged for service of process, and they sent the notice. There's one thing that should be in here on this list, the notice of the hearing, because the other side, once they're served, has to be given 10 days notice of the hearing date, so that notice will be in the file. And then one of your jobs is to look through that and help them fill out look through those forms. You haven't even talked to the client yet. You're just looking at the file and you're looking for things that were missed or omitted or nobody knew about at the time of the office interviews, because you want to mark that, you want to get that filled in before you're going to start your other work. And there's one form that you usually never see in private practice when you're representing a client, unless perhaps you represent criminal defendants, because a lot of times they don't have very good jobs. It's that motion that start on here, the motion to file without payment of fees. And you want to make sure that's in there and it's been filed. It should have been filed. If it's not, then you can fill it out and go over it with the client. Again, there's staff people there to help you. If you've never filled out one of these before, you say, wait, look at this, it's not completed. Before I talk to the client, what do I need to ask? How do I fill this out? And you'll get the help you need. Okay. Let's go to the next slide. So you're still looking at the file. Haven't talked to your client yet. And the first thing you want to make sure that's in there, these are forms that likely have not been filled out in the clinic phase, but likely you'll have to fill out. One of the most annoying things about these forms to me, let me turn to the program administrator and say it to her. One of the most annoying things for me is that all these forms that I have to fill out the captions, because at least in the files that I've seen, they haven't been filled out. So it's a small price to pay for doing pro bono work, I guess. The motion and order to appear and withdraw is special. It's a special form that MVL has prepared for you to fill out. And this is your motion to enter your appearance and to withdraw your appearance from the case at the conclusion of the permanent orders hearing. And you'll have to have the client sign off because they have to consent to your withdrawal from the representation. All the judges, all the magistrates know you're with MVL, and all of them know that every time they hear one of these cases, they're going to get one of these motions. It's not a surprise to anybody, and they would just sign it as a matter of course. All right. Also in the file are the permanent orders. Now, if you work, you already do DR work, you know that in the judicial department has a separate form for parenting plans for the kids' issues, and a separation agreement for property issues and other issues related just to the two parents. MBL's made it easier for you because they've taken those two judicial department forms and combined it into one form. So you only have to fill out one caption, but it makes it a little easier. And this is one of the situations where you won't get an official fill in the blank form to fill out. So we'll talk about what the issues are for the permanent orders and form, the MVL form in a few minutes. You're also going to prepare a child support worksheet and a maintenance worksheet. Now, back in the Stone Ages, when I started practicing law in Colorado, I could take a pen out of my pocket and a calculator, and I could figure out child support and maintenance. That hasn't happened for years and years and years. And all of us, if you're not involved in DR cases, all of us that are involved in DR cases have software programs, and there's 2 or 3 different ones, but they all do the same thing. Because it's really complex and there's tax implications and child care tax credits and all these other things that nobody that trained for litigation like me would have any idea of what to do. The good news is the program administrator with you at MBL has his or her laptop and have the program on. So once you get the numbers to plug into the empty fields in the program, then you just hand that to the program administrator that's with you, and that person will print out the child support worksheet and the maintenance worksheet. You're in good shape. There's also a support order. Support order is a judicial department form. It's not really one page, but if I were making it, it would have been, just put it that way. And this is an order that goes to the finance people of the courthouse. So it's all on one page, all on one form as to what the amount of child support is, what the amount of maintenance is, if there are any past due maintenance or child support called arrearages, whether there are any arrearages and how those are going to get paid off. So the finance people have it all on one page, and you'll have to fill out that support order. The support order works for both child support and spousal support or maintenance. Last thing you have to fill out is the decree of dissolution, and it might be an allocation of parental responsibility, so you have to have a decree for that. So those are the things that will be in blank in the folder, and you're going to have to work on. You check the other ones to make sure they're complete, and you're going to have to work on these as you talk to the client. All right, you're done looking at the file. So now you have to go out and meet your client. One of the things that isn't in the slides, and I should have told you, is that once you go into the room, check in, and you get the file, what I always do, I know it's going to take me 15 minutes to go through all this and fill out captions and do this and that. And if I have enough information, get started on the computer program, child support worksheets. As soon as I get the file, I walk back out in the hallway and I say, let's see, is Bill Russell here? Is Sally Smith here? Whoever your client is. And I introduce myself because they've been sitting out there for, who knows how long, 15, 20 minutes, maybe an hour. And they have no idea what's going on. All they know is that there's somebody in a nice courtroom outfit who walked into that room, and they're just sitting there. So when I get their names, I go out in the hallway, I introduce myself, I tell them, I'm going to be looking at your file. It's going to take me 15 minutes or so. Once I get through the file, I'll come back out. By the way, you're the petitioner, you're my client. Is the respondent here? And if they say yes, I'll go over and introduce myself to the respondent. Because you're going to have to negotiate with this person. You're going to have to talk to this person. You want to make people comfortable, as comfortable as they can be sitting on wooden benches in a courthouse hallway. Then I go in and I do the file reviews. All right, if we can go to the next slide. All right, let's see a show of hands. How many people know who this is? right? It looks like 6 of you. All right. Nobody in this room raised their hand but me. So this happens to be Angela Merkel's successor. Angela Merkel's the Chancellor of Germany. This is Olaf Scholz. And he is the new Chancellor of Germany after Angela Merkel had that position for years and years. And soon after he was elected Chancellor, he went to France to meet with the President of France, Emmanuel Macron. And so just like you and I or anybody that goes to France, the first thing you do is you get in line and you have to go to passport control. So Olaf Scholz hands his passport over to the passport control officer. Officer opens it up, looks at the picture, holds it up, looks at him, says, "Can you your name, please?" And he says, "Olaf Scholz." Officer says, "Occupation?" He says, "No, I'm just here for a meeting." All right, that's only funny if you're a history buff. Next slide. This is the out of order slide that we just covered about when you check in, you go get your assignment and then you go back out and talk to the folks and you go and introduce yourself, you go back in and do all that with you. Okay, next slide. And interesting. Yeah, is there one that says review the file? Okay. Oh, somehow this is all on me. I changed it without telling anybody. Okay, let's review the file. So you're reviewing the file and you're going to complete the captions and you're going to look for issues and you're going to ask for help. But let's talk about some common issues that come up when you review the files. First, you look for missing information in any of the forms that you're going to be filling out, and even in any forms that were previously filled out in the clinic, because you don't want a judge asking your client about some missing information and you weren't ready for that, because these clients are unsophisticated. So one of the questions that came up earlier from Kim is, what do you do about updating the sworn financial statement? Because the sworn financial statement will be filled out in the clinic. Let's say that's day 1. And whatever day the person fills it out has the information as day 1. And then MVL has to serve the respondent, the husband or the father. And that's going to take some time. And once they serve the other side, or if they have to serve by publication, that's going to be another couple months. Once they get that service, is that when you file the case?
No, we file.
Okay, they file and then serve. And then once they're served, there's going to be a scheduling of a family court day, which happens, I think, 1 day a month in Adams County and 1 day a month in Jefferson County and 1 day a month in Denver County and 1 day a month in Arapahoe, and you go to Douglas separately?
Yes.
Yeah, and 1 day a month. So there's another month. Maybe you made it, into that first month, but maybe you didn't make it into the second month. So there's some more time that goes by. And then you schedule the hearing. And you got the hearing scheduled, but the hearing can't be until 92 days after service, right? Because the judge can't enter any orders until 92 days after service. So maybe there's another couple months. Well, remember on day 1, that client filled out what their checking account balance was and what their credit card balance was and all their other assets and liabilities. And that all of those have changed, right? So do you need to update? Do you need to update on the day? Do I need to do that on the day I walk in? I ask if there's been any significant changes. If there have been significant changes, material changes in the words of Rule of Civil Procedure. There have been material changes in assets and liabilities. If somebody won the Powerball, well, they probably shouldn't be an MBL anyway, with this, motion to file without payment of fees because I'm poor. But if there's been a material change, then I'd say yes. But for most day-to-day changes, stuff that's pretty similar, I don't think you really need to change that. And it's going to take you a long time to get that changed and refilled in. So unless it's really significant or really a material change, just go with what you have. All right. Issue spotting. Issue spotting is relatively easy in this situation. The reason I say it's relatively easy is because in that orientation booklet that you're going to get, it's going to have a list of issues for you to check off in your mind as you're reviewing the file. And there's going to be things like standing. Is there standing? Is there personal jurisdiction? Have the children resided in Colorado for 6 months, 182 days? Have the party, at least one of the parties, been domiciled in Colorado for 91 days? All right, now I'm going to switch gears because I was kind of a geek when I was a judge. That may not be a secret to some of you. And the statute talks about domicile, but lawyers regularly ask if the person has been a resident in the courtroom. Have you been a resident of Colorado for at least 91 days? And those are not the same things. But it's very hard to find out the difference. It will take you a good hour looking at case law to figure out the difference, because so many cases don't make the distinction. But I'll tell you what the distinction is. You and I will be the only two people that will know this, so don't get excited by it. You cannot live within the boundaries of the state of Colorado, and it's still your domicile. Domicile means a temporary absence with the intent to return. So if you're on a member of the National Guard and you've got your month training out in Fort Benning, Georgia, you're still a Colorado domiciliary. But if the issue comes up, it's not easy to find those couple cases that make that distinction. All right, now we'll get back to our program. You got this checklist of issues to spot. Personal service in Colorado. Has there been a waiver of service by entering an appearance somehow? And the respondent typically is always going to be pro se. I've never had a situation where a respondent was represented. Maybe it's happened, but it's never happened to me in probably the 15 or 17 years I've been doing this work. If they file something, if they file their own financial affidavit, if they file whatever it is, that will be a acceptance of personal jurisdiction of the court, even if there wasn't personal service of that person. And has there been enough time passage since the case was filed? It's 91 days in case of a divorce, and I think it's 30 days in case of an allocation of parental responsibility where there's been no marriage. And was the notice of hearing? All these things for you to check off are listed in that orientation guide. The other thing that's important for you to ask about, which is in this guide, are there any prior orders in most of the time involving the children? And those orders typically come in two ways. Number one, maybe there was a dependency and neglect case that had been filed and handled before the divorce came up. I'll give you a typical circumstance. You got parents that are on drugs, and I bet that 98% of the dependency and neglect cases where the parents are, where social services has intervened, get the court system to intervene. I bet they're all drug related. And even the ones that we think are mental health are drug related. So maybe there was a dependency and neglect case. And as a domestic relations lawyer, I didn't really understand how this worked. But once a parenting plan is approved in the dependency and neglect case, it gets, and everybody's happy and the parents are on some plan, and the dependency and neglect court enters parenting plan orders. That case gets closed and it gets what's known as certified over to the domestic relations court, where it can sit forever. maybe the parents are just fine and they go on with their lives and the kids are doing great. And that case will sit in the domestic relations courtroom and nobody will ever look at it because there'll never be any action. Be just like a closed DR case. Or maybe child support enforcement got involved somehow before the MVL got involved and filed the divorce petition. And they established child support for parents. Is that usually in APR cases?
Typically, APR, every once in a while, we will have a dispute.
Okay. All right. So most typically, a mom will go to child support enforcement because she's got the kids when there are no orders in place. That's a typical scenario. And child support enforcement of the county attorney's office will enter a child support order with that worksheet and all that stuff. Ask about those, because if there's already a parenting plan in place and they're already following it and they're already happy with it, you don't have to go through the whole deal about negotiating another parenting plan. And if there's already a child support order in place and there haven't been any significant changes in the incomes of either parties or significant life changes, substantial and continuing, the words of the divorce statute, then you don't need to really worry about that. Just ask your clients. But it's really embarrassing if you don't know about these orders and they're in place. And so you go ahead and do the regular parenting plan and child support order in there. And the judge doesn't know about it because maybe they didn't tell MVL. And even though there's this divorce case kind of sitting dormant over in the divorce court already, nobody told MVL. And the parents didn't know it got certified over. They just know they used to have a dependency neglect case. It's really embarrassing when somebody finds out later on that there's two conflicting child support orders in there. So you want to ask about that. That's one of the things on the checklist they give you. And then if you're new to this, or even if you're not, look for oddball issues. My last MVL case some months ago, we had a real oddball issue. We had a child support situation, and the child support computer program has a place for how much the dad makes, how much the mom makes, and who pays, whether the mom pays for medical insurance, dad pays for medical insurance, usually through an employer, and they get credits for that. So, odds and ends things. So my client wasn't mom or dad. My client was grandma. And grandma got custody of the kids out of a dependency neglect proceeding. And so grandma comes in and she wants, maternal grandma comes in and she wants dad to be paying child support. I knew what dad's income was. I could put that in the computer program. Whose income do I put in on the mom's side? So every once in a while, you get some oddball issues. Ask the other attorneys in the room that are looking through their files. Ask the program administrator who's there with you. There are people that have been through these oddball scenarios before, and they'll be able to help you through. And that's another reason why starting out with an MVL case, if you're new to this, or even new to litigation generally, makes it much easier to do. Oh, and the other reason is you get malpractice coverage because you're a volunteer, right? So it makes you even happier. It's a happy day, right? Okay. Can we go to the slide that says client interview, please? Okay. So you go back out in the hall, you're ready for the clients, you bring your client into the conference room with you. And suddenly you look, and of course you know this because you introduced yourself out in the hallway. There's not one person in the room with you. There's two. Sometimes there's three. Who's your client? Well, it's pretty easy In this case, if it's a mom, you can identify the client. Who's the third person? This is the ethics portion of the seminar this morning. Who's the third person? A lot of times, it's just like in your office when you do this. A lot of times it's mom or dad. The client's 18, the mom's 18, the dad's 20. They're not worldly. They bring in a relative, they bring in a friend, they bring in somebody else that they want to help them through the process. So you have to advise them about something that they may have heard of, they won't understand, and mostly they don't care. And that's the attorney-client privilege. Because it's more important to them to have a friend with them in the room than it is to worry about something that they don't really understand anyway. But you are still ethically obligated to advise them about the attorney-client privilege, and the presence of a third person may be a waiver of the attorney-client privilege. But there are times when the presence of a third person is not a waiver of the attorney-client privilege. So I'm going to give you two citations. One is to the Colorado Rules of Professional Conduct, and it's Rule 1.14. And the rule is called clients with diminished capacity. Well, I'll read you what the comment says, but mostly your clients don't have diminished capacity. They just need a friend or a relative in there with them. But here's what the comment 3 says to the rule. The client may wish to have family members or other persons participate in discussions with the lawyer. When necessary to assist in the representation, the presence of such persons generally does not affect the applicability of the attorney-client evidentiary privilege. All right. When necessary to assist in the representation, but they're talking about necessary to assist in the representation of a person with diminished capacity. Next citation. Fox versus Alfini, A-L-F-I-N-I. The citation is 432 Pacific 3rd, 596. Let me tell you the facts of the case. A 30-year-old plaintiff sues a chiropractor for malpractice, alleging that the malpractice resulted in the 30-year-old plaintiff's stroke. The lawyer and the 30-year-old lawyer and the 30-year-old's parents meet for an initial interview, which the lawyer, as a matter of course, records. During discovery, the defense learns that the lawyer recorded the interview and demands production. And the response, of course, is attorney-client privilege. And now the court has to determine whether the privilege applies when the parents were there in the room. So the trial court rules that the parents were not necessary in order for the plaintiff, the 30-year-old plaintiff, to consult with the lawyer. And because they were not necessary, the privilege is waived. An appeal is taken to the Court of Appeals. And the Court of Appeals does what the Court of Appeals sometimes does. And in one place recites a standard, and in another place recites a standard using different words. And the meaning of the different words are not the same. The intent might be, but if you look at the words, they're not the same. So here's the quotation from the Fox case. The presence of a third party during an attorney-client communication will ordinarily destroy the privilege. unless the third party's presence was reasonably necessary to the consultation. The language in the rule of professional conduct is necessary to assist in the representation. Necessary to assist in the representation. And this language is reasonably necessary to the consultation. The Court of Appeals affirmed the trial court because the trial court found not that it wasn't reasonably necessary for the consultation, but it wasn't reasonably necessary or wasn't necessary to get communication between the attorney and client. And the Court of Appeals followed a line of cases that suggests that, let's say you have a client with diminished capacity, then that client needs help. But this 30-year-old didn't have diminished capacity. The 30-year-old just wanted his mom and dad there. That's who you're going to find when you take your client into the conference room, is somebody to comfort them.
Judge Moss, would you give that citation again,
Sure.
please?
The case is called Fox, F-O-X versus Alfini, A-L-F-I-N-I. And the Colorado citation is 2018. I have CO 94. And the Pacific Third citation is 432 Pacific Third, 596. Now, if the Court of Appeals had just stopped and they said, you know, the trial court found that the parent's presence for the 30-year-old stroke victim wasn't needed, the parent's presence wasn't needed, and there's substantial, we may disagree with the conclusion, but there's substantial evidence, so we affirm. If they just stopped, it would have made me happy as both a trial judge trying to figure out what to do and for you folks. But they went on and they said, in reaching this conclusion, affirming the trial court, we are not unmindful of the necessity in some circumstances for clients to have third parties assist them during attorney-client consultations. Nor should our ruling be read to discourage some assistance when it's necessary. We merely conclude that on the facts of this case, the district court did not err when it found that Fox had not shown the requisite necessity to preserve her claim of privilege. So if they had just stopped and said, trial court was right, you need some real necessity, you need diminished capacity or something or other like that, rather than just a feel-good friend, that would be fine. But what they said was, well, the trial court decided this and there's substantial evidence to support the finding of fact, and we can't go past that. But we're going to tell you, not in every case. So you're still kind of hanging out to dry. That said, as I started this discussion, I've never had well, maybe once I had an MVL client say, oh my heavens, I'm going to kick out my mother. Usually it doesn't happen. I'm going to kick out my best friend because I'm afraid that someone will breach the attorney-client privilege. Because frankly, the person on the other side is trying to get this done before you turn into a pumpkin, and the issue will never come up. But that's the warning for you, the extended warning for you. All right. So you also want to ask the client's goals, and client's goals you should ask about, again, this is in the checklist, parenting time, decision-making for the children, property division, child support, maintenance, child tax exemption, post-secondary education, anything else. And you've got all these checklists all ready for you, so don't worry about memorizing that. And you can supplement the forms with any missing information that needs to be put in there. And then you always ask your client about what do you think the other side wants, because most of the time when the other side turns up, or appears, and even when they don't, the other party, they've had some discussions and they got stuck with each other because they're surprised they don't like each other. Okay. And then if you have the if you have the other side's sworn financial statement, you'll have the income figure to plug into the computer formula for the child support maintenance worksheets. And if you don't, ask your client, what does the other party make? What's their gross income? And that's good enough evidence for a judge. You ask that question in the contested hearing, judge only has, assuming personal jurisdiction, that's the only evidence the judge has. You ask your client on the witness stand, or probably more often than not, sitting at the counsel table with the microphones, how much does the other side make? And your client says $150,000 a month, and the judge writes that down, and you plug that into the child support worksheet number. And there's substantial evidence to affirm that determination. Okay, so now you got your client's position. Now let's see about the negotiate slide, which in my version is 13, but I don't know which one is yours. There we go. Okay, so now you have to go back out and talk to the respondent. And this is kind of like any negotiation, or if you do mediations like I do, you get a feel and you decide whether it makes sense to have the parties in the same room, or whether you want to talk to the respondent separately. And you go through all these issues and you get respondent's position. And if you're not in the same room, you shuttle back and forth and try and work it out. Most of the time, many, many times, you're not going to have a respondent. So that makes your negotiation much shorter, right? And next slide, please. Okay. So two French chefs were competitors. One threw a hand grenade in the other's kitchen. Fortunately, nobody was injured, but there was some linoleum blown apart. So next, complete the forms. Complete the forms, get signatures, your client, respondent, if respondent's present. Go into the courtroom. Before you go in the courtroom, give the two parties a little brief rundown about what's going to happen in the courtroom. You're going to sit here. There's going to be a table that says respondent. You'll sit over there. Occasionally they want to sit together, but it's really easier for the judicial officer if they're sitting behind their placards that say who's who. Tell them the questions they're going to be asked. I just run through it quickly. I'm going to ask you these questions on the decree. Is your marriage irretrievably broken? How long have you been domiciled in Colorado? How long have the kids lived here? Just all the standard jurisdictional questions. Is this your separation agreement? Is this your parenting plan? Yes, it is. Do you think it's fair, just, equitable? This is all in the script. You'll be handed a separate script, either for a DR, a dissolution, or for an allocation of parental responsibilities. Tell your clients about magic words: fair, just, and equitable, irretrievable breakdown. Just run through it quickly. I just run through it quickly, just so they're not surprised when they get in the courtroom, and then go to the courtroom. I tend to be kind of slow. There's always people that make it to the courtroom before me, so we'll be sitting in line, and the magistrate or judge will either be on the bench. They'll say who's next. They'll say you're next, and they don't know your name. They just figure out which one of the three people in the room are the lawyer. Point to you. You're up, counsel. You come up. You hand over whatever paperwork you have to hand over. One of the problems with this, by the way, is that you only have the original at this point of the separation agreement parenting plan. And so a lot of times I do not hand the judge the separation agreement and parenting plan right away, because I want to use it, want to be able to hand it to my client and say, hey, you've seen this, did you sign it? All the standard kind of stuff that's on the script. But you can hand the decree, and you can hand the other stuff, and you for sure want to hand that motion to enter appearance and withdraw. And typically that's the first thing out of my mouth. And I say it because you're being recorded, and I want to get it on the record. Your Honor, I may approach the bench. I've got this, and I got that, and I got something else. And I have this motion to enter appearance, withdraw, and I'm requesting that you allow me to enter in at the conclusion of the hearing, withdraw. And the judge will probably turn to your client and say, is that okay? And you've already told the client you're going to do that, and they say yes. Never had anybody say no because pretty much they don't understand what's going on about that. Okay, so you go to the courtroom. Next slide, please. Okay, so use the script, get court signatures on that motion to withdraw. The decree will likely be mailed, will be mailed to the parties sometimes. It depends what jurisdiction you're in. Sometimes you can convince the division clerk who's sitting there with the judicial officer to go back and make you copies right away of all these documents. Sometimes MBL has access to a photocopy machine, but not always. So I always like to get my clients copies of whatever I can before they leave the courthouse. And that could even include copies of the decree. It won't be certified. If they want certified, they have to go down to the court clerk. By the time they get down there, hopefully, the division clerk will have already typed in judge orders entry of decree, and maybe probably won't be scanned in yet, but it's possible they could go down and get a certified copy. Just depends on timing, but at least they'll get it mailed to them, sent to them by mail after it gets scanned and goes through the regular clerk filing process. And then you want to get copies of whatever you can, not only for the client respondent, but for the MVL file. I don't know whether they want that in their file, but they can always throw it away if they don't. That's the way I look at it. So that's what you do at the hearing. You go through the script and you're doing great. So, last thing. So now you're all done and you go back into the conference room where the program MVL, Metro Volunteer Lawyer Program Administrator is waiting for you. And you say, hey, we're done. Great. And you make notes, very short notes in the MVL file. There's a one sheet of paper in there, and on the bottom half it says put down any notes you have, and I put decree issued, separation agreement, parenting plan signed off. There hasn't been an agreement. I say there's been no agreement. I always tell the program administrator there whether there was or was not an agreement, and then any follow-up steps that the judges indicated to you or you know about, like they still need a decree or something, like just very brief. And the MVL program administrator will know how stuff gets to your clients. You don't have to worry about it. Okay, and finally, one more thing, your last steps. Next slide. Go back to your office. Tell everybody this was really easy. They'll know that you're a hero. You tell everybody in your office that because you did pro bono for the firm, they owe you a lunch. And if you get back early enough after your morning session, you can force them to take you to lunch right then. And then you turn around and you sign up for the next family law court day. Because A, you're going to enjoy this. B, you're doing a good thing for your profession and for yourself and for people that otherwise you may never have met. So that's everything in, one more thing in my presentation. Do not show this next slide to your children.
There you go.
Okay. All right. If there are any questions, just put them in the chat. And Sahar's back here with me.
Yeah, I'm just gonna
Sure.
So
touch
you can
base.
tell us about the happy Thanksgiving.
Yeah, well, you know who's on the table.
A little self-explanatory. No, I just wanted to touch base a little bit on some issues that I think come up that a lot of people have questions about. So there's the FLCP program, which is obviously wonderful. I think when you're doing the cases on your own, these uncontested cases, a lot of times questions come up around two major things, and they deal with money. One is child support. You know, as Judge Moss explained, we all virtually use programs. We use Math for Law. I think there's family law software. Yeah, there's a few big ones, but I mean, they all do the same thing. Some are more user-friendly, in my opinion. People have their preferences. But really calculating child support is going to be kind of major. You don't need too much information, but the major things you really want to know are gross incomes. That's something that I have to talk to my clients a lot. And sometimes people don't get it, is it's gross income. You know, rent doesn't get pulled out, expenses aren't pulled out. It's your gross income that they're looking at. And don't just rely on the client's first number that pops out of it. Because they might just say, I get this much an hour, or this is what my check is. Or if you're looking at their checks, you really want to calculate what that gross income is going to be. If they're a W-2 wage earner, that's the easiest, right? This is how much they get paid, either their salary or their hourly rate, and you calculate their gross income, and it's easy. It becomes a little bit tougher if they're a 1099 or self-employed or have other sources of income. You know, you're not really going to be dealing with these in simpler cases, but do they have business income, capital gains, things like that, or if they're going to be an issue. But gross income, and then you're going to want to look at obviously the number of overnights with each parent. So under 92 overnights, it's going to be a worksheet A, which kind of keeps things relatively straightforward. Once you kind of pass that threshold, or if you're at like a 50-50 where you're doing 182 and 183 overnights or something like that, that those number of overnights really do make a difference in the child support calculation. Then there are some other factors that go into play. The two biggest ones are really going to be, as Judge Moss mentioned, who covers the kids on their health insurance, usually through their employer, through FLCP, because, you know, these are kind of income vetted people who are coming through. They're likely going to be on Medicaid, so you don't really need to deal with that. But if it's not that situation and somebody is actually covering the children, it's the cost to cover the children. So not what they're paying totally every month for themselves, or maybe they have a new spouse or anything. It's the cost to cover the children. And so a lot of times their employer might provide them a breakdown of, this is the total cost, this is employer plus spouse, employer plus family, and you can figure it out. If not, what you can do is, let's say there is the person covering the children, maybe that's father and two children. What you would do is you would take the whole amount and take 2/3 of that, because there's two children. So 2/3 of that total amount is really going to be used to calculate the cost covering the children. And then something else that comes into play a lot of times is work-related childcare or education-related childcare. You know, do they have these childcare expenses that they need to provide, you know, daycare services or things like that while they work, and kind of who gets credit for that. And the software really just kind of plug in the numbers and plug in the caption information, and the software really does provide you what that figure is. A lot of times, you know, I think people don't realize sometimes how high child support is going to be, and they're very shocked, or they want more. And, you know, what you really got to think about is it's the right of the child, and really there to ensure that the child's needs are taken care of. And so child support, there's always a lot of questions around child support. Now in the clinic, as Judge Moss mentioned, we just kind of put in information, and Liz is able to provide you with that number and provide you with the worksheet. But those are kind of the major things that go along with that. And I just wanted to touch on that a little bit. And then that's one of the reasons why that sworn financial statement is also kind of critical, is it does have that income information on there. It does ask about cost of health insurance, or, you know, if it's a mandatory or it's a voluntary deduction from their child, from their pay stub, or if they're paying out of pocket, what the premiums are. That's all documented in the sworn financial statement as well. Another big aspect of what the sworn financial statement does is, since it has the assets and the debt sections, is it really does provide a look at the entire marital estate, because in a dissolution proceeding, that entire estate needs to be divided. Even if they've been separated for years and people have their own bank accounts, this is a misconception most people have, that something is in my name, that bank account is in my name. Anything during the marriage, whether they're separated, not separated, in whoever's name, anything acquired during the marriage, assets or debts, needs to be divided. It's a part of the estate. That's something that sometimes clients can't wrap their mind around, or it takes a little bit of time for them to wrap their mind around that, you know, well, is he going to get my bank account? Is she going to get my retirement? That's mine. It's in my name. I haven't seen them in years. And, just kind of explaining that process to them. Colorado is not a 50-50 state, but we're an equitable division state. So as long as it's fair and not unconscionable, the court is going to generally approve that. So that sworn financial statement really is a critical document. And then a couple just kind of practice pointers when dealing with kind of clients, some issues that come up a lot kind of in the clinic, and it may come up in your private practices. A lot of times language is going to be a barrier. We have a lot of clients that come through FLCP where English is not their first language. They may not speak English at all. I think that ties a lot in with having a third party there. Is that person there to just translate? Do we need to provide translation services? If you speak another language, make it clear, Liz, from the beginning. You never know what language services somebody might need. That could also slow down the process a little bit because you're speaking, the person translating is speaking, the client is speaking, and making sure there's nothing lost in translation to the extent possible. For the actual hearing, if English is not the primary language spoken by the individual or the respondent, there will be a translator provided, which I believe Liz arranges beforehand. So it's not going to be an issue at the hearing, but they're not going to be out there in the meetings beforehand or at the client meetings beforehand or any of your consultations. So just kind of making sure that is kind of taken care of. And then some other things to kind of be cognizant of with these situations is, a transportation could be a major issue for them, even just do they need to take the bus? Do they have a car to drive, make it to the hearing on time? Kind of being aware that they need to take time off work. Can they take time off work? Are they financially able to, come meet you many times, or how much are they getting up early to try to come to that hearing? Kind of if there's any restrictions with that, or like time they need to get back. Do they have adequate childcare? Childcare could be a major issue. I like kids. I never want to see my clients' kids. The clients' kids should never be in the courtroom, should never just, I believe some courthouses do provide childcare. Do they do that? Yeah. So if that's an issue that they're going to arrange on their own beforehand, that's fine, but you do not need the children should not come to the meetings or appear at the hearing or anything like that. So arranging childcare. And, that can be difficult for a lot of clients if they don't have, the financial ability to do that, or supportive friends or family or somebody who can help. And then another thing too, that I've also kind of come across in my years with FLCP is a lot of times, as Judge Moss mentioned, these aren't, the most sophisticated of clients with their finances and things like that. They might not know, and they might not know what you might consider potentially basic information, right? A lot of times, when did you get married? They don't know the date of their marriage. They don't know a lot of these things. And, you really got to be aware of their situation and, not judge. And it's just, they don't know. And you try to get as much information as you possibly can. You're not going to obviously put information on the form that you don't know. You're not going to guess, but try to get as accurate as you possibly can. But being aware that just like with the sworn financial statement, where it's going to take them time to think through, okay, how much is my electricity bill every month? How much do I spend on shampoo and clothing and, those types of things? It takes time to really make sure that you get accurate information with other things as well that you might consider very basic. So just kind of knowing that adds to kind of the time. And then with the forms that Judge Moss mentioned at the end, the separation agreement, parenting plan, that's kind of in the permanent orders. Those are pretty standard forms. If you are using those, I would say, be as detailed as possible, especially in these cases, if the respondent shows up and there's an agreement and there's this desire to be, they could be on good terms and still want a divorce. They could be friends and still want a divorce, or need APR orders in place and custody orders in place. And they think, we're going to work it out and it's going to be fine. And we agree, or we'll talk. That's great if that happens, but that's not always the case. And so you really just got to advise them that you need to be as detailed as possible with times and holidays. And, that is the fallback. If you don't agree, what is the order going to be? So the more details you can put in there, the better. So those are just kind of some issues that I usually see with kind of these cases and through the program, and some things like that. And so I just want to reiterate also that volunteering through FLCP is really a great way to go through this whole process and not be with somebody, with the support of MBL and the staff and other volunteers. And so you can do the client meetings and the permanent orders. You can do this whole process and but just having that support with you so that whenever you're ready to do it on your own, if you ever want to do it on your own, you've already been through it. You've already been in front of a judge or a magistrate. You've already been through a hearing. You've already seen what needs to be covered. You know the jurisdictional issues and the questions that need to be asked, the forms that need to be completed. It's not brand new to you. So it's a great way to really get started. And as I mentioned before, you don't need any family law experience, and anyone can volunteer, retired, not retired, law students, paralegals, people you want to reach out to. It doesn't matter what area you practice in law, what field, anybody can volunteer, and we're always looking for wonderful volunteers.
Thank you both. There was a question about bank accounts. Do new bank accounts require information to be disclosed to the other party if parties separate and then a new bank account is opened?
Yes.
Always disclose.
Yeah. Well,
Go ahead.
as Sahar mentioned, with just a couple exceptions that usually don't apply to Metro Volunteer Lawyer clients, anything acquired during the marriage is marital property. And during the marriage means before the decree is entered. So it doesn't really matter when people physically separated or whether they're physically separated. As long as the income was earned during the marriage or the funds were received during the marriage, that's marital property subject to division and the divorce. Now, one of the exceptions is inheritances and gifts, but mostly your clients aren't going to have inheritances that they received during the marriage that they kept in a separate account in their separate names. And mostly your MBL clients aren't going to have any gifts of any financial significance. So if it's earnings, doesn't matter who earned it. Both of them are going to say that's not hers, that's not his. Yes, it is. It's an equitable division, and that has to be ordered by the judge. And the risk is, if they don't get it ordered by the judge, and it's a significant amount, and in these cases it probably would be, because mostly they don't have anything, and they don't disclose it, the other side can come back under the statute and under the court rule 5 years later and say, hey, that wasn't disclosed. Let's do this property division all over. Now, the odds of that happening with an MBL client are really tiny. A couple of things I just want to comment on. If you've not done the domestic relations cases and you don't have the child support software, don't think you have to buy it. Metro Volunteer Lawyers has it. They have it on their laptop. It's at every one of these family law court program dates. The program administrator there is going to do it for you and explain what numbers you need. And you're meeting your client, you come back, say, I got all the numbers, and somebody say, oh, you need one more number. Here's how you do medical insurance, and then you go back and get it. Don't buy any software if you're not buying the software anyway. You've got other lawyers that are volunteering that morning. They're going to help you. Everybody's going to help you. Child care. I don't know. I only know how it was done in Adams and Broomfield counties before I left in August of 2020. And the way that courthouse did it was they have daycare providers in the general vicinity of the courthouse under contract. But you have to call them up ahead of time to make sure they've got space for a 3-year-old on that court date. So don't expect that a mom or dad with kids are going to walk into the courthouse and say, where's the nursery? Check, if you're like me and you just show up for permanent orders, then you're dead in the water. But unless they bring grandma with them and grandma can take the child for a walk or something like that. But if you're in the clinic and your client needs daycare, find out how they do that. And the last thing was this health insurance calculation thing. I think most everybody's in Medicaid for their children. Is that your experience?
For
For
most-
M-
the
metropolitan-
most part,
Yeah,
yeah.
so you don't really have to worry about splitting up the Medicare costs. It's not really an issue. Okay, any other questions we got?
I don't think so.
So sign up and get all these free materials and try your hand at it and see if you like it as much as I did. And so one of the things I look forward to about retirement is that I was free to do things that I wanted to do for the league, for the law.
We do have another question. Maintenance. If the other party has a new partner that's supporting them, if that party is not working during the divorce proceeding, does the court take that into consideration?
Imputed.
So they can stay the parent, but if they traditionally have worked or have supported or contributed to the marriage, like they'll impute income. So it's,
Imputed income, the first case that I'm aware of from imputed income was a medical doctor who practiced with 2 or 3 other medical doctors in an office and was making, $1 gazillion a month. And he or the wife filed for divorce, and suddenly he had a employment agreement with his partners where he made $1.75 a week. And the Colorado Supreme Court said, no, we're going to impute. We're going to, as a matter of law, pretend that you are capable of making a certain amount of money. And for the most part, if it's obvious, then they'll impute the income. And if it's not so obvious, they'll impute at least Colorado minimum wage, which right now comes out to
$12.56.
$12.56 an hour or $2,177 a month. I believe if you multiply $12.56 times 40 hours a week and then do the rest of the math.
Yeah, you'll want to look at, there's statutory language about voluntarily underemployed or unemployed in case law that support that. So maintenance would be in 1410, 114, and for child support, it's 115. So you want to kind of look at that. And it's very similar in child support. They'll impute income because you're not supposed to shirk your child support responsibility. Some things to keep in mind is, you really want to think about, is that person voluntarily unemployed or underemployed? I think in a lot of my NBL cases or FLCP cases, when they're not working, I really want to find out why aren't they working? Are they receiving disability benefits if they've been classified as disabled? That's really one of the things that I look out initially and then kind of dig deeper into, are they capable of actually earning more money than what they're claiming?
And what you'll mostly run into is you'll get the sworn financial statement from the respondent and it'll say, I make $1.85 an hour. And your client's going to say, he makes $17 an hour. So that's what you got to negotiate out. And by the way, if you run into that, you don't know what to do, go back into the room with the other lawyers and say, what do I do? And they'll tell you.
Thank you. So thank you everyone for joining us. Thank you, Judge Moss and Sahar, for a wonderful presentation. This was great and informative. And we will be, it's being recorded, so we will have it edited and put up on our website. Again, everyone, please, if you're interested in volunteering, obviously our speakers have told you how easy it is to do it. But you can go onto our website, which is denbar.org/NBL, and volunteer to help with us. We have a number of programs where we are always looking for volunteers. So thank you for your time. We'll be sending materials and the PowerPoint out by email after, and have a wonderful day. Thank you both so very much.